During the first few days there had been a steady stream of correctional personnel coming up to the floor just to get a look at me. But now they were turned away at the door by the officers assigned to me. The rule was solid. No one was allowed to come into the room without being on the approved list. Even my attorneys had to be searched. Anything coming into the room had to be logged in the book. Sam took a copy of the rules and left with Leroy and Superintendent Patricks to go to the warden's office to resolve some of Sam's objections to the regulations. After working them out, he returned alone to talk to me about the possibility of my helping the sheriff's office identify some of the victims so that they could be given a decent burial. He assured me that my assistance would be off the record and could not be used against me. We would meet in a conference room downstairs, and he would be present at all times. I questioned his reasoning in wanting me to assist the same people who were trying to put me away. His response was, "Don't worry, John. Whatever you say at this time is exempt from being used against you at any time." Since he was representing me, I felt that I should do as his legal mind dictated. Assuming that his interest was the same as mine, that my welfare was his prime concern, I consented to meet with these people. Present at the meeting were Lieutenant Frank Brom and Investigator Philip Bedeker of the Sheriff's Office, Greg Bordeaux, Sergeant Joseph Hine, and Larry Finder from the State's Attorney's Office, and Amirani. There was no one transcribing what was said at the meeting, no one taking it down word for word. Yet later in court this would come out as Statement Number 5, iterated from memory. After a 3.5-hour bullshit session of questions and answers, speculation and disagreements, more than one person talking at the same time, Statement Number 5 was evidenced as a verbatim recapitulation of that meeting. They had a 10-page statement typed, which said they were quoting me word for word. I later told Sam I didn't think this was done right, and I thought it would come back to haunt us. But he was sure none of it would be used against me. They had given their word. I learned that Sullivan had been there too. He hadn't come into the room because he felt that, because of the rough way he had treated me that first day at the police station, his presence might keep me from talking. Not a day went by that I wasn't page 1 news. People were coming out of the woodwork saying that they knew me or that I had attacked them. The Chicago Tribune and Chicago Sun-Times played the body count game, each day changing the headlines with updated numbers, each trying to outscoop the other as the count rose. During the week of January 3rd, 1979, a grand jury was convened and returned 7 murder indictments against me. All of the victims remained nameless at the time. The arraignment. On January 9th, I was told that I was to be arraigned in a Des Plaines courtroom at 10 o'clock on 7 counts of murder. The assigned officers went over life-saving procedures with me, what I should do if shots were fired, which way to turn, where to go in the courtroom, in the car, how I was to hit the floor while an officer covered me, the same if we were walking. Because of bomb threats, some 250 law enforcement officers are going to be used to protect me at the court building. All the rooftops in an area of a square block around the building were under surveillance, all of it cordoned off. There would be 2 groups of cars leaving from the jail, one as a decoy for the media to chase, while we would slip out the back in an ambulance with 10 officers. They worked on these plans for most of the day, only to cancel them the following morning. A last-minute court order rescheduled the arraignment to the 26th in California, the criminal courts building, a day later. Prior to the hearing, Amirani introduced me to Robert Mata, who he wanted to become his co-counsel. All along, Amirani had wanted to get rid of Stevens, since he was a civil attorney, who, as he put it, wouldn't be of much help in criminal matters. Not knowing anything about criminal law, I guessed he was right. I sure needed 2 fighters. I had asked Sam to contact F. Lee Bailey. I would like to have him on the case, Sam. Amirani claimed he would, but in the meantime he would have Mata appointed and at his side for the arraignment in the morning. I told him I was scared, after practicing all these procedures, like me crawling under the table if shots were fired, and an officer falling on top of me until the shooting stopped. January 10th, 1979. After I showered, shaved, and combed my hair, I was given my street clothes. The place was a beehive of activity. My assigned officers shined up their badges and belts to be sure they were photogenic and natty. Assistant Warden Glotz came in, introduced himself, and said he was in charge of escorting me to the courthouse, along with 5 officers. Since I had my jacket on, I assumed we would be leaving the building, but this was not to be. We took an elevator to the basement, where we waited until given the call, the all clear to proceed. We followed a labyrinth of underground passages, with a vanguard inspecting each curve along the route before our cluster moved along. We reached the connecting basement of the courthouse by way of a holding pen, where many men were waiting for the day's court. They were made to stand up and face the walls while I walked through the area. All the elevators in the building were taken out of operation, except the one I was to use. We rode up to the 4th floor. We're led down a hall lined with officers standing shoulder to shoulder, all the way to the door that took us behind the courtroom. As we got closer, the crowd got thicker. When I finally entered the courtroom, it was like a 3-ring circus. Standing room only, everyone wanting to get close to me, to be in the forefront of the picture. At the far side, there were 10 prosecutors and a score of law enforcement officials, including Sheriff Elrod and State's Attorney Bernard Carey. At a long wooden table sat my 2 attorneys. Behind them, a dozen bailiffs stood like wooden soldiers. As soon as I sat at the table and said a few words to Sam and Bob, the court clerk started reading the murder indictments. One by one, the names came down. Robert Peast, John Bukovich, John Zick, Gregory Godzik, Rick Johnston, Frank Landigan, James Mazzara. Amirani entered pleas of not guilty to all indictments and asked the court to dismiss all indictments. Basically, Amirani argued, the motion is to dismiss all indictments based on not only pretrial publicity, but pre-indictment publicity, Judge. Judge, I think nowhere in the annals of the criminal justice system in this country, or in any country for that matter, has there been so much pre-indictment publicity, pre-criminal process, pre-critical stage publicity. I think Your Honor realizes that, with the sophisticated modes of the news media, minicam, so forth, live from the scene reporting, prejudicial publicity which may or may not be true, which may or may not be used at trial, which may or may not be admissible in a grand jury proceeding. All of these matters being put before a grand jury for purposes of indicting a person. None of us in this room, especially here, my client or I or Mr. Mata, will ever know the amount of taint that was placed that was placed on the grand jurors because of the nature of a grand jury proceeding behind the secrecy of a grand jury had to be tainted. There was no way the grand jury could not have been tainted, could not have known of the pre-trial publicity. It has hit literally millions of people throughout the state, throughout the country. And for that reason, Judge, we are asking to dismiss the indictments based on pre-indictment publicity, which is tainting the minds of the grand jurors. Quoted from pretrial transcripts, pages 7 and 8, State of Illinois versus Gacy. Next, Amirani argued that the entire proceeding was being held illegally because it had been transferred from the 3rd District to the Criminal Courts building without compelling judicial reason. Des Plaines was where the case belonged, and we had not asked for a change of venue at that time. One after another, Amirani continued to bring forth motions. Competency to stand trial, sanity at the time of the alleged offenses, examination for fitness, motions of discovery, habeas corpus to produce Robert Peast. Then, he brought up petitions which he had filed on January 4th, relating to and against the Sheriff's Department and the medical examiner of Cook County, Dr. Robert Stein, to show cause why they should not be held in contempt of court for violating the court-imposed protective order against releasing publicity to the news media. The judge admonished those present that the order would have to be upheld, and any further violation of that order would be dealt with severely. At that point, Judge Fitzgerald assigned the case to Judge Louis B. Garippo, who would hear all the other motions to be brought forth. Amirani continued with more motions and raised the issue of the illegal search warrants. He requested a cease and desist order and prosecution to show cause why the questionable warrants were not on file. Only one warrant had been filed, the one issued on December 13th. There was no record of the one on December 21st, the search that was still in progress. Also, there was never an inventory of what had been confiscated given to anyone thus far. A long discussion ensued, with the state making all kinds of excuses as to why that responsibility had been ignored. The judge said he would turn it over to Judge Garippo to hear any arguments. Bada raised the issue of the state holding my car and trucks again and protested against the destruction of Summerdale property and personal effects. He continued that the vehicle should be released or that the state should show cause for confiscation. The state asked for pretrial discovery from the defense and said they would be seeking the death penalty in the case if facts were presented which would authorize them to do so. Before any other motions could be made, Judge Fitzgerald declared a court recess during which Judge Garippo could be brought in to hear all additional motions. 11 motions had been filed by the defense, and there were 34 pages of transcript for this part of the arraignment. When we returned to the courtroom, the huge crowd of spectators pushed and craned to get a look at me. The jury was teeming with media and artists sketching as fast as they could. Judge Garippo took the bench and the court was called to order. After the reintroductions of the concerned parties, Amirani resumed, advising Garippo of the 11 motions he had filed. He wanted immediate hearings on certain ones. The judge took the pile of motions, went through them, and decided which ones did not have to be heard at the time. When he reached the search warrants issues, Amirani stopped him, stating that the state had not even given us the first warrant, and noted that we have seen nothing, as far as we know, unless we missed. There was nothing posted at the house. I think statute calls for, if the copy of the warrant is not served, it is to be posted. A copy of the warrant is to be posted at the premises. This has not been done. The reader will note that quotes of defense counsel, prosecution, and members of the judiciary are verbatim, taken from the record, and not edited. January 10th, pretrial transcripts, page 35. Garippo. Those should be turned over immediately. Kunkel, for the state. 5 what? 5 separate warrants. 5 separate warrants. Well, they are in the court file? Only one is in the court file. We indicated to Judge Fitzgerald that we have not been served with a copy of any search warrants, as far as we know. Judge, there is no search. Emirani moved for a cease and desist order in connection with the search warrants. January 10th, pretrial transcripts, pages 39 to 41. Emirani. Judge, that is in regard to our motion for production of the search warrants. Our basic argument to that was the search at this time has become redundant. It has become a fishing expedition, and should not be continued until prior application has been made to this court. I think it would only be appropriate under the statute, and under the Fourth Amendment, that law enforcement officials, state's attorneys, and all related personnel come before the court to show probable cause. We're not asking for something unlawful. We're merely asking the law to be complied with, and that the state show this court probable cause in regard to a reasonable search. Garippo. Well, the only problem I see with that is that if counsel does have a point with whatever is done between now and the argument date, the questions that arise, When was the last search warrant issued? Same transcript, page 43. Garippo. Okay. All right. Here's the thing. Your motions are on file. The state is on notice of your complaint. They proceed, I should say, at their own risk. They proceed knowing about your objections. What Judge Garippo failed to do was act on the order to cease and desist and follow the law as it's written, Chapter 38, Section 108. Why wasn't a legal search allowed? Why did the court, after being appraised of that illegality, later allow it to stand without probable cause? That was a case of outrageous arbitrariness by Garippo and his letting the state get away with a flagrant violation of statute law. By the state's own admission, a search was being conducted without the warrants in the hands of the court. I could already see what publicity, public pressure, and political influence had to do with getting a fair trial. Garippo was bending. The next issue brought up was the 2 contempt of court motions against Sheriff Elrod and Dr. Stein for violating the protective order against giving out prejudicial information to the news media. Pretrial transcript, pages 49 and 50. Emirani. Judge, I just want to indicate to this court, I realize this is your first day on the case, but there has probably been no case any time in the history of our criminal justice system that has received so much pre-indictment, pre-trial publicity. I would ask this court, at this time, in regard to the protective order, to strongly admonish the state, the defense, for that matter, strongly admonish all personnel and all witnesses involved in this matter to comply with this protective order. And I would ask this court to completely scrutinize the actions of any personnel involved. Kunkel. Judge, I don't think... I would certainly disagree with many of the statements that counsel has made. And made a statement here, I don't think any particular response is in order on our behalf. We agreed that the order at the beginning. We believe We have complied with it, both in the spirit and the letter from the time it has been entered, and would have any way an intent to continue to do so on behalf of the people of the state of Illinois. Yet, that wasn't the case. Kunkel knew there had been leaks from their office. Sullivan knew it too. Quoting Terry Sullivan from his book, Killer Clown, page 180, "By Saturday morning, I was alarmed by some of the information pouring out of the press. Obviously, there were leaks galore from the sheriff's policemen, from Des Plaines, and maybe from my own office as well. A day later, parts of Gacy's statements were appearing in the press, plus a lot of other information that was dreadfully erroneous. That torrent of leaks, allegations, innuendo, and accusations were deliberately set forth to cover up the wrongdoings of all the law enforcement agencies involved in the case, with the hope that mass publicity would create public pressure against the defendant, John Gacy. The final thing brought before the court that day was the state's attempt to justify the two official charges, possession of a controlled substance and possession of cannabis. Amirani was quick to reply, "We have received no copies of the complaints." He told the story that he was present in Des Plaines and knew about only one complaint at that time. Wary that the state might even bring up erroneous charges to cover up the illegal arrest, he demanded an immediate trial on those charges. Garibbo complied, but it was never to come to pass. He moved right along, setting dates for hearings on the other motions for January 24th and February 18th. Amirani then pushed for the court to assign case numbers for the two contempt petitions. Garibbo assigned Dr. Stein case number AC 79004, and Sheriff Elrod case number AC 79005. Neither case was ever brought to trial, just quietly dismissed in political style, Chicago style. My arraignment was continued to February 28th, 1979.